You can request for permission to file for divorce before the 3-year mark if you or your spouse have experienced exceptional hardship. This is mentioned in the Women's Charter. What counts then as exceptional hardship? Not every marital problem qualifies as exceptional hardship. It must be something out of the ordinary, a problem that no ordinary person should endure. The specifics of what actually counts as this will vary from each case to case. But here are some examples you can consider. In Singapore, there's a legal requirement that you can't file for divorce until 3 years have passed since you got married. This rule aims to preserve the value of marriage and prevent it from being treated lightly like a simple contract. However, there are some exceptions to this. A spouse has had numerous affairs with many people since the beginning of the marriage. One spouse disappears immediately after the marriage. Continuous physical violence causes severe injuries to one person. There's abusive behavior which leads to severe psychological impact and problems. A spouse committing adultery even at home, or developing a severe illness due to stress caused by the marriage. What doesn't count as exceptional hardship? Isolated physical abuse without serious injuries, where there's a reasonable chance of reconciliation, when the interests of a child born from the marriage are at stake, stress is caused by controlling in-laws, a single instance of adultery, career disruptions due to the marriage, difficulty adjusting to each other's ways or families. If, however, you have already been married for 3 years and are planning to get a divorce, here are the steps you can follow. Step 1. The spouse seeking the divorce, which is the applicant, must file a writ in the family court, stating the grounds for exceptional hardship. Step 2. The other spouse, who is the respondent, can respond to the application, but if the respondent doesn't object, the matter proceeds to the judge for a hearing. Step 3. The judge evaluates the facts and circumstances to determine if exceptional hardship has indeed existed and taken place. If so, the judge grants permission for the divorce within 3 years of marriage. Step 4. If the judge isn't convinced by the evidence, the petition is then dismissed and both parties must then wait for the 3-year mark from the date of the marriage registration to file for divorce. Step 5. If the judge grants an interim judgment, the parties must resolve ancillary matters such as dividing assets, child custody, spousal maintenance, as well as costs. Step 6. The court issues the final judgment for divorce once ancillary matters are settled. Besides proving exceptional hardship, you must also demonstrate the irretrievable breakdown of the marriage. This can be due to unreasonableness, adultery, or other circumstances. If there is a chance of reconciliation, the court won't grant the divorce. If the court discovers that one party misrepresented or concealed information to obtain an early divorce, it can lead to serious consequences. According to the Women's Charter, if the court already granted an interim judgment, the final judgment won't be issued until the 3-year period has passed. The petition may be dismissed if the court hasn't granted an interim judgment, and the parties can reapply for divorce after the 3-year restriction has ended. If the court doesn't allow an early divorce, there are other alternative options you can consider. Annulment of the marriage. You can seek an annulment which completely dissolves the marriage as if it never existed in the first place. This is only possible if the marriage is void or voidable. Personal protection order. If you fear harm or harassment from your spouse, you can apply for a personal protection order. Spousal maintenance. If your spouse neglects to provide reasonable maintenance to you, you can apply for spousal maintenance. A deed of separation. Parties can choose to live separately by signing a legally binding document called a deed of separation, which outlines the terms for the separation. Judicial separation. Either party can also apply for judicial separation, which makes it no longer mandatory for the spouses to live together. So, now you know. If you found this helpful, follow and subscribe to our channel for more legal things.